Hi, everybody. I hope you guys are having a good night or good evening or afternoon. I'm studying so much, I don't even know what time of day it is anymore. I can't even remember how many times I've gone live today. But I was here earlier doing some Civ Pro, which is short for civil procedure, which is like literally like the procedure of civil cases. Um, And now I need to review some flashcards before I do some questions. Not about Civ Pro, about torts. And if you don't know what torts are, I kind of tried to explain it in the title, but it's basically anything that causes you like a harm that's not criminal. So something that you can like sue someone for money. Olap, oh my gosh, hi, Olap. I need your genius because I started to try to make AI songs to study with. And I just like Googled like AI song generators because I remember all the words to all the Olap songs. So I was like, maybe I should make a study song. And I think it worked, but I just need tips on how to make catchy ones because I think it actually helped. But if you have any tips about making catchy songs, maybe not your secrets, but please let me know. May I I'll have to play some of them too, because some of them were really catchy and they worked when I was answering questions earlier today. Okay, let's go through these flashcards, and this is good to do before I review my questions. Yeah, okay, so I'm just gonna write reports. Okay, good idea. I'm glad you think so. Yeah, I was like, if I remember every like OLAP song, I guarantee I can remember like a study song. It was really funny. I was like walking around singing about like mortgages and stuff. So I am really going to try it. I have another month or so until the exam, so I have some time to play around with it. Okay, my first flashcard is battery. What are the elements of battery? Um, it you have to intend to have something contact someone else. It has to actually make contact. The contact has to be offensive to a reasonable person. I do not believe you have to suffer damages, but you might have to. No. Good job. Okay. So, intend to cause contact, actually cause contact. Contact is offensive to reasonable person or causes bodily harm. Got it. So like, and that includes if it's something attached to a person. So like, or like if it's something like if you throw something at a person, like that would be battery, but it has to actually make contact. And that's what's different between battery and assault because battery has to actually make contact, but assault will come up and assault you don't have to make contact. You just have to make them like scared that you'll make contact. Um, okay, anyway, that's not the flashcard. This flashcard was about battery. Got it. Oh, the next ones are what are the elements of assault? So I believe they kind of changed it between, well, okay, so um, you have to intend to cause a reasonable anticipation of harm. I'm not saying that quite right. But you have to intend to cause the person to be scared. The person has to actually be scared, and they have to be aware of what happened. That doesn't sound quite right, but let's see. Reasonable apprehension of offensive contact caused by the defendant. Okay, I basically kind of got it right. Okay. Causes reasonable apprehension, which just means like fear. So like assault is just the fear of something happening to you. Battery is when the thing actually happens to you. Um, okay, so causes, so, well, so causes reason, get someone scared um, of harmful contact um, caused by actions or threats. I don't like how, I'm going to rewrite this. So you intend to cause reasonable apprehension. You actually cause reasonable apprehension. And intend to cause reasonable apprehension, actually cause reasonable apprehension. The by actions or threats of imminent harm. Okay. So the two big differences between battery and assault. Battery does not require any, battery does require actual contact, but you do not have to be aware of the battery. Assault, you do not need contact, but you do have to be aware, because the most important element of assault is the fear that something will happen to you. So if you don't, so like if someone like winds up their fist like they're going to punch you, but you don't see it, that's not assault, because if you didn't see it, you didn't get scared. Ooh, Olaf, thank you for these tips. Make sure you split the blocks of text into verses. The prompt is just verse 1, verse 2, of course. Okay, smart. That's the first step to make it flow and not be so rushed together. Okay, good, because I wasted a bunch of credits on like making really crappy songs. So I know when I was not doing what you just told me to do. But I'm gonna have to get back on here later and play some of the songs and see how catchy they are, because I feel like that would be such a good study tool for people. Okay, I did battery, I did assault. What are the elements of intentional infliction of emotional distress? Well, it has to be conduct that is egregious and outrageous, and it has to actually cause emotional distress. And I think there has to be actual damages. And you have to intend for the emotional distress. Okay. This is IIED, which is intentional infliction, emotional distress. But lawyers will just say IIED because it's just faster to say. Okay. So you have to intend or be reckless, extreme, outrageous conduct, that causes severe emotional distress. And this is really hard to prove. Intentional infliction of emotional distress has to be something like really crazy, like something that it would just completely like shock the conscious. Yeah. So like even saying like someone hit a dog, that, and like if the person were to say like that caused me distress, like that's not even egregious enough. To It has to be something that's just wild. Okay, what are the elements of false imprisonment? And all of these torts, or all these things that you can sue for, are all intentional. So that's why I tried to keep the first thing on my list the intent, because I want to remember that each time for each thing. So it's well, not the last intentional tort, but this next one is false imprisonment. And what are the elements of that? So you have to intend to confine somebody. You have to actually confine somebody. I'm pretty sure there have to be actual damages, meaning like they have to suffer. I mean, not like dramatically, but there has to be something to sue for. Um, you intend to confine, you actually confine. Oh, you do it without authority and actual damages. Intend to confine causes a confinement. I knew this one. You have to know about the confinement, but I thought there were some. Okay, yeah, they say sometimes you do not have to know you're being imprisoned. Wow. Okay, so you have to intend to confine, actually cause confinement, and person knows they are being confined. Yeah. And it also works, it's not just confining someone, it's also not releasing somebody. So if you like if you're in a locked store and they won't well, that's kind of like confining, but if someone could like open the door and let you out, um like that would be imprisonment too. Um so what I mean is you could put someone in a locked closet, or if you find someone in a locked closet and you don't let them out, both of those would be imprisonment. Okay, let's go to trespassing. So trespassing is not, gosh, I'm a little rusty with torts. It is not intentional. So even if you don't intend to trespass, you're still liable for it. Anyway, the element, well, trespassing to land is just entering, I think it's just entering land that doesn't belong to you. Yeah, an intentional act. Yeah, so you just have to mean to go onto the land. So the defendant's intentional act has to cause a physical invasion. Um, um, intent to enter or invade. Yeah, land, someone else's land. And that could be like even throwing something on someone else's land. And your pets can also trespass on someone else's land. And it doesn't matter whether you know it's someone else's land or not. That's the only thing is required, just you meant to step on the land. Imagine finding someone in a locked closet and not letting them out. Right? Some of the cases that oh my gosh, I need to go over some of the cases that they tell us in law school because the weirdest, strangest things have happened. And I guarantee there's a case where that probably has happened. Okay. What is the definition of trespass to chattel? Now, I never heard of chattel until I got to law school, but it just refers to things. Chattel just means things. So trespass to chattel is basically like using something that doesn't belong to you. Okay. Yes. So you are intentionally interfering with the possession by either taking the thing away or using it. Okay. Now, intend to either dispossess or use intermeddle with the chattel. dispossess. Okay, and this one does requires actual harm from use or deprivation of use. Okay, so for some, because for some things you can sue in court even if you didn't suffer. So for example, you can get, they're called nominal damages. So like trespass is one that like you might get like $1, because like even if they didn't hurt anything on your land, it's just the concept that like you are owed something. I mean, $1's not great, but it could literally be that. Some things you have to actually like have damage or harm happen to sue somebody. So again, for like trespassing to land, they don't have to hurt anything. You could just sue them for, even though there's nothing to pay for because they didn't damage anything. But for trespass to chattel, if someone takes something of yours, you have to actually prove that like you suffered because they took it if you're going to sue them. Okay. So then conversion of chattel is when you mean to like, you steal something. Oops, sorry if that was loud. You intend to permanently dispossess someone of something. Did I say that right? Yeah. Intentionally depriving someone of their possession. Yeah. Intend to deprive use of something. So like if you were to, someone left their like Lamborghini outside or something, and you were on a road trip and you hopped out and you took it like 3 states home and kept it for yourself, that would be conversion of chattel. And chattel is just another word for thing. I don't know. I mean, I know why the law does this because it's just super old, but yeah. Oh, hi, Amelia Tess. Amelia, you let me know if I'm saying that right. Also speaks to level of interference as well. Yes, that's a really good point because you could not actually physically take the thing, but like mess with it so bad that they can't use it. So like, I feel, what would be an example of that? Like if you like took the engine out of the Lambo, I think. Let me know what you think. I feel like that would be like conversion too. Yeah. Okay. Oh, and this word, I always forget the word replevin. You may recover damages. Let me put this. May recover your full value or bring action for replevin. And I don't know why I can never remember what replevin means, but that just means recovery. Let me look up a better definition of replevin. I mean, I know vaguely it means like you're getting money back that you're owed, but that's not exactly right. It's not even money. It's to take back property. Okay. Take back property. Okay. Definitely, or something taken for an extended duration of time. There's so many variations of it too. That's what I feel like I have a hard time figuring out the line between trespassing and conversion. And I mean, I think that's something they test on a lot too. So that was a good point. Torts was my least favorite class, so this is actually really good for me. What are 2 situations in which a plaintiff's express consent will not constitute a defense to it? Okay, when can you not consent to an intentional tort? like fraud, like misrepresentation, and I'm not sure. What can you not consent to? What can you not consent to? I don't know. Oh, what? Oh, I read the question wrong. Like, when is someone's consent not valid? And that's if it's made under mistake or duress. I got it. Um, yeah. Um, wasn't that a weird, that was a weird question, right, Amelia? Um, I think I read it wrong too. But yeah, it was what is it? This is the way it's worded. I'm gonna put it up here. What are Oh, I guess that makes sense. I just read it wrong. What are two situations in which a plaintiff's express consent will not, I guess, like be a successful defense? And that's if they're saying if it's given um under mistake or duress. Okay. When may a defendant act in self-defense, and how much force may the defendant use? Um, they can act in self-defense when they are like, what is it, like reasonably expecting. Wow, I need to brush up on my torts like vocabulary words. When they're like, well, when it's the only way that they think they can stop from themselves from getting hurt or killed. I just cannot remember what the legal way to say that is. But you can use self-defense when you think that's the only way to stop whatever's about to happen. And it has to be like a physical injury to you or somebody else. Um, and you can only use an equal amount of force. So, like, if someone's going to punch you, you probably can't shoot them. Am I gonna get banned from YouTube for saying that? I don't know. But probably those aren't equal. Okay, let me see if I was right. Um, okay, yes, you have to reasonably believe that it is necessary and proportionate to what you're protecting from. Okay, got it. Self-defense. You have to reasonably believe, um, force necessary to prevent harm, and use equal amount. Well, I guess I want to say equal proportionate force. And I know I've seen on a lot of tests, them going back and forth between who's doing the self-defense, because I think it's like if someone is the like attacker and the victim defends themselves and the attacker retreats, if the victim says, "Oh no, you're not going to retreat," and goes back after the attacker, now they're flipped. And then the victim is now the attacker, and the attacker can now use self-defense, and self-defense won't work for the victim. I'm pretty sure I have that right. So whenever I see these on tests, I feel like I always have to be really careful to pay attention to who started it and like who walked away, because you can't attack the person who is retreating. And I don't think it will work. Let's say if someone's going to punch you and you do like, I don't know, like lethal force, um they, I believe, can also use like raise their amount of force too in self-defense. Um and it won't be seen as attacking. Ooh, Okay. And they can have a mistaken belief as well. Can be mistaken belief of danger, which doesn't really need to be said, but it just has to be reasonable. And it also applies to defending other people too, I believe. But I'm sure I'm going to get a question about that. Okay. What are the 4 elements of negligence? That should be easy. Duty. So you have to have a duty to take care of somebody. You have to breach that duty, meaning you fail to take care of them the way you should. You have to cause, is it damage? I think you have to have damages. You have to cause damage. So if it's like negligent, well, let me double check that I'm right. Yes. Hey, okay. You have to have duty, breach, causation, and damages, which is like the harm that you suffer. Got it. Cool. Yeah, that's good. Got it. Oh no, what question is this? What are the Andrews and Cardozo views regarding the foreseeability of a plaintiff? Oh, I'm gonna put this up here. Okay. So I know, I don't know who believes what, and I don't know I don't know what they believe, but somebody of them, I think, believes that, shoot, I don't know. I mean, it's something about how, if it's an unforeseeable plaintiff, like, then you aren't responsible. They can't sue you for negligence. I don't know. I'm going to say some things and F this up. So let me look at the answer before. Okay. So Cardozo believes, or believed, the Cardozo view, and this is that, and these are the last names of I think they're Supreme Court justices. Yes, they must be. Yes, they are, of course. I think that's so bad how I don't know my history of the law that much. A duty of care is owed only if they're a member of the class foreseeable plaintiffs. I do remember this. Got it. Okay. Sorry if I'm like talking in half sentences and not making sense and stopping and starting, but I promise if you give me a second, I get there. Okay. So Cardozo thinks you're responsible for, well, negligence of plaintiffs that you could foresee being harmed. And Andrews believes, if I remember, if you think one person could be harmed by your conduct, then you have to make sure nobody is harmed. Yes. Okay. Response, if one person can be harmed by conduct, or let me put it this way. If you can foresee harm to one person, you are responsible for everyone. Okay. I didn't say that the most elegantly. But this is about, and I should put majority. So majority means most jurisdictions, like most states, will follow this Cardozo rule. But there are a few states that follow the Andrews rule. And like on the test, they'll ask you, like, this jurisdiction follows the minority view of foreseeability of a plaintiff. And you just have to remember like what that is. But okay, so what this is about who can sue basically for negligence. And Cardozo, his view was you can sue as long as you were someone who could be expected to be harmed. If you couldn't be expected to be harmed, then you can't sue. Andrews thinks that as long as one person could have been harmed, anybody can sue. In a way, that's kind of what it means. Okay. What is the firefighter's role? Okay, from what I remember, this is you can't if you're going to rescue somebody, you can't sue them for like the conditions you find them in. So it's called the firefighter's rule because if you're running into a burning house and like you get injuries, you can't sue the person whose house was on fire because that was the whole point of like you knew you were going and that's the whole point of being the firefighter. You're the one that's supposed to run into the fire. Did I say that right? Let's see. Yes, an emergency professional cannot get damages when it's from a risk inherent to the job. So emergency professional can't sue for harm caused by the emergency. And I think that makes sense. Like if you're getting called to, save someone from a fire and you're running into it, it doesn't make sense to sue them. Okay. What are 6 circumstances in which a defendant has an affirmative duty to act? Okay. I don't know. Let me see if I remember. Affirmative. So in torts, so in general, you don't have a duty to save someone. So I think it was Olap who was in here earlier. We were talking about false imprisonment and like if someone's locked in a closet and you walk past, if you like own the closet, like it's your responsibility to let that person out, even if you didn't put them there. But let's say you don't own the closet and you don't know the person, you don't know what's going on, you don't know if they're in there on purpose, then you can walk by and not let them out. You don't have to actually help them. We don't actually have a duty to help. And I feel like some people don't know this, but once you do start helping somebody, you want to make sure you're prepared to help them. Well, that's not true. You always want to help somebody, of course. But if you start to help somebody, you can't abandon them in the middle of helping them. You don't have to be like successful in helping them. But once you start helping them, you have a duty to continue helping them. And that's what they're asking about here. When do you have an affirmative duty, which affirmative means like the opposite of passive, like it's an action. You have to actually do something. So anyway, one of those times is when I was talking about when you rescue someone. I know if you have like a special relationship, and I know I have a feeling that's not going to be clear enough, but it's going to be like if you're in a caretaker position. I'm gonna have to look at this list. I can't think of them. Okay, I should also. So this is called assumption of duty, which means you're assuming the duty of rescuing someone. With ordinary care. Oh, if you put someone in danger. I forgot that one. Place in peril. Owe them reasonable care. Okay. You also, okay, by contract. So if like you sign a contract that says you'll take care of this person, um, if you have authority, so that's like a parent over a child, or maybe like a manager over a supervisor, that type of thing. Um, you have to have reasonable control over the person you're controlling. And there's that one that I was thinking of. Special relationship. Um, that can be like common carrier, which just means like buses, trains, planes, like the people who operate those have a duty to you to make sure you're safe. Innkeepers also have a duty to make sure like, you know, their premises are safe. There's other ones too, but yeah, but those are just some examples. I'm not going to put all of them. And then the last one is by statute, which is like means by law. So, um, so there might be some laws that say like, let me look up an example. So for like landlord tenants, that makes sense. Like lots of city states have like codes and laws about the care landlords have to owe tenants. And that's governed by the housing codes. So, um, do, 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 like housing codes, probably like food, people who prepare food, I bet. Um, yeah, because you have to follow like the health code and stuff. Okay. So now I need to make sure I remember those six. So you don't usually have a duty, but when are the times that you do? There are six types of six situations. And if I sound like I'm talking like a robot, it's because I'm literally like looking up at the ceiling and up and away and seeing if I remember. If you assume the duty, so you start rescuing someone, you need to exercise ordinary care. I already forget the second one. Well, if you have a special relationship, um, like the common carrier, innkeeper, if you have authority over someone, you have to exercise reasonable control. If it's by no, shoot. If it's by statute, sorry, that's the one that no, that's not true. By statute could be like tenant landlord. Oh my gosh, I'm messing these up. Okay, if you assume the duty, if you place the person in danger, that was one I forgot. If you have authority over someone, if you have a special relationship, if it's required by statute, or if by contract, then you have some standard of care or some duty. I didn't like that. Okay, that'll be fine. All right, in negligence actions, what is the general standard of care? That is a reasonable person under the circumstances, I believe. Reasonably prudent person under the circumstances. And it is objective, which I always think it's funny when they say it's objective because it never really feels objective. Like I've read so many cases where judges think something is reasonable that like I do not. Like I forget there's one case it's a criminal well, I always think it's just very like interesting what judges think are reasonable or not. And when they explain their reasoning, literally their reasoning is just like, I don't think that's reasonable. But anyway, we say reasonable is an objective standard. Hey, Massachusetts. Hey, Olap. Oh, I'm so glad to have some people here. Um, okay. Now, and okay. Um, what is the standard of care imposed upon a child? I believe, I don't know. Oh, okay. Um, for a child, it's a, okay, for adults. So for adults, if you're going to decide someone's negligent, you're going to ask, did they act like a reasonably prudent person under the circumstances? Okay. But if they're a kid, um, you are going to ask if they acted like I think it's a reasonable child of the same age and intelligence and experience. Yes. Reasonable. Have you ever met a reasonable child? Maybe. I used to teach kindergarten, and there's some. um. Oh, Amelia, you're like way ahead of me. I love that. A child of like experience, capability, etc. And I love the etc. because it just means that you know it that well. Like it just like I can tell you already had the list in your head. CH, like a reasonable person in stalking and harassment codes. Defining reasonable is a rabbit hole. It seriously is. And it kills me that it's like treated as objective because you could argue forever. Amelia, with the minor exception for the rule of seven. I like vaguely remember that from Torts. So like if you're 7 years old or something, I'm glad you brought that up. No, that was not right. I don't think that was right. Amelia, you'll have to educate me. Let me know if I was right or wrong about the rule of seven thing. Yes. Okay. Whew. That makes me feel better. Any children, I'm gonna shut up. Um, any children age 7 or below cannot be found negligent in some jurisdictions. Thank you for that note. Thank you for the correction. Amelia, are you studying for the bar or are you a lawyer? You're very smart. That's why I'm asking. And all of you are very smart. I could just tell she's like specifically smart in this area. Um, okay. Um, name the three types of entrants to whom a possessor of land owes a duty. I don't know what I just read. The three types of entrants to whom a possessor of land owes a duty. Okay. Who does. Oh, you're studying for July too. Okay, good. I'm glad to have you here with me. Um, yeah, because this is so boring to do by yourself, and at least talking out loud helps. Um, landowner duty. Okay. So there's three types of people. You have a licensee, you have an invitee, and a trespasser. And what do you owe to each? The licensee, you owe the lease to. The invitee, I think you owe reasonable care. And this, I think you have to avoid willful. I'm going to look before I start typing because I'm going to mess everybody up. Okay. Yes. Trespasser, you have to avoid from willful, wanton, reckless, or intentional misconduct. So you can't be setting up like bear traps that are going to like clamp off someone's leg or something like that, for trespassers. Okay. A licensee, you have to either warn or correct. And licensees are people who are just coming onto the property for I sometimes get licensee and invitee mixed up, but pretty sure a licensee is the one who comes for a limited time and purpose. And an invitee is basically just like a guest. Let me double check that before I say that. See, yeah, Amelia, I think you might be right because I get licensee and invitee mixed up. Let me look this up real quick. Yeah, good job. You're gonna kill it on the bar. Perfect. And it's funny because I remembered it because I mess it up so much. So I'm actually glad you said that because I wasn't making up that I get confused with that. Okay. CH, mail carrier versus a dinner party. That's actually a really good way to remember it. Let's see. So licensee, I should write this down. Business. No, this is your guest. This is your dinner party. Am I right? Yes, for money, for a commercial benefit is an invitee. And the license is just a guest. Okay, I should do this. Oh, I have to go to dinner soon. That's not right. All right, so what do you owe to an invitee? You owe I think that's, well, let me just pull this up. Oh, I was right. You do owe the invitee reasonable care to inspect and discover dangers. Okay. And protect from them. And then your guest, that's the one I think you have to warn or correct. Yes. Warn of or correct concealed dangers that landowner knows of or should. Okay, so now I have to make sure that I get that. Oh, let me see what you guys are saying. Okay, I'm glad it's not just me that it seems like they're backwards. Amelia, you're doing great. Oh, thank you so much. That's really nice to hear. You're doing great too. It's actually really fun to have you here. And UCH, it's fun to have anyone here. Invitee delivers the invitations. CH, oh my gosh, I love that. That's so smart. That's really, really funny. I like that a lot because I was just telling Olap, who, if you haven't seen Olap's videos, she makes like musicals. I was like playing with AI songs, making like property musicals, and it kind of worked to help me memorize. So I want to play around a little bit with it more. But I definitely love tricks. It helps me to think of slip falls at the grocery store for invitee. Oh, that's a good one. That's a good point. Yeah, that's exactly right. Um, Sorry guys. One second. Okay. Um, Actually, think I'm gonna get ready for dinner now. I might be on later. I'm gonna go out to dinner when my roommate is moving out, so we're gonna go out to dinner. But I feel like this is a good place to stop. I'm really happy that you guys came and joined me. I'm definitely just turning notifications on because I just pop on randomly. But yeah, I probably should be back here after dinner, so maybe I'll see you guys later. But hopefully see you the next time. I hope you have a good evening, and I'll talk to you guys later. Bye.